Hello, and welcome back to Hagan's New Jersey PIP Tips, where we bring you monthly segments on New Jersey auto insurance personal injury protection, otherwise known as PIP. It's been a few months since our last video. We've been really busy here between our PIP arbitrations, all the other work, and then personally, you saw from my last video, my youngest son graduated from college. He subsequently came home to New Jersey to have his tonsils out, which was a little bit of a long recovery, followed up by his graduation party before he went back to Nashville. And then once everything was starting to get back to normal, unfortunately my mom had some heart blockage and had to get a pacemaker installed. So it's been a crazy couple months, both work-wise and personal. I've heard from many of you saying, hey, I haven't seen a video, need to know what's going on. So here it is. Today we're going to be talking about the GEICO Class Action lawsuit. Unfortunately, a decision came down that was not favorable. I'll explain the details along with the good and the bad that comes out of this. We also have our featured provider of the month, Perrone Wellness Center. And then finally, we'll pick our new winner for the next video. So let's get right to it as it's long overdue. If you've been following my videos for approximately the past 3 years, you know we had a class action lawsuit that we were trying to proceed against GEICO regarding their improper taking of applications for insurance and not obtaining a covered selection form. We felt like we had a strong case. We filed in New Jersey Superior Court. GEICO moved it to federal court. The federal court severely limited our discovery. We conducted discovery, and then once the discovery period was over, GEICO filed a motion for summary judgment. We responded to that motion, pointing out conflicting evidence, actually their own conflicting evidence, their own documents that showed that they did not obtain a covered selection form on this case, along with contradicting evidence from our insured, or our client, their insured, who testified that she was familiar with what a covered selection form is, as she for the first time saw one and filled one out almost 6-7 years after she applied for insurance, when she went to make a change because she was involved in an accident and learned the differences in PIP coverage and what it means. So she knew what a covered selection form, and she knew she never saw one nor signed one. After sitting around for almost a year, the court scheduled oral arguments, heard it, and actually found in favor of GEICO on a summary judgment, despite the conflicting evidence, despite the contradictory evidence of even GEICO's own evidence. It was very disappointing. It was not the standard for summary judgment. Summary judgment is when, as a matter of law, a party's entitled to a judgment based on the evidence, and there should be all inferences in favor of the non-moving party, so in our case, the plaintiff. There was definitely conflicting evidence, and it can only be granted when there's undisputed evidence. Additionally, the district court applied the law wrong and ignored the fact that they did not obtain or even attempt to obtain a covered selection form during the application process, and ultimately, in my words, dummied up a covered selection form after the fact. We subsequently appealed to the Federal Appellate Division. We submitted a detailed brief explaining the errors, that it wasn't a summary judgment standard, meaning that it wasn't inferred in favor of the non-moving party, that there was disputed facts, and that the judge got the law wrong. After 5 months, approximately 5 to 8 months, after indicating there was going to be oral arguments and asking us what times we were available, the court decided it on the papers and did not grant oral arguments. Eventually, the decision came out by one judge, not the whole panel, and he affirmed the district court's finding in a 7-page decision, which most of it was just reiterating the history. This is the first time that I'm this seriously disappointed in our legal process, but we don't believe, I had co-counsel who were specialized in class action lawsuits, and they don't believe this is a case that the Supreme Court would review based on the level of the Constitution, etc. So this puts an end to this specific case at the federal level. However, it does not close out the case. There's some bad news and good news that comes out of this 3 years of litigation. The bad news is the case is dismissed, and this case will not be certified as a class action against GEICO for their improper process and action regarding the coverage selection form. However, there's some good news that came out of the case too. First of all, the opinion, because it was issued by one judge of the panel and without oral arguments, the court specifically indicated that it's a non-presidential opinion, that it's not of the full court, and does not constitute binding precedent. So this doesn't end the story, this does not end the argument, this does not end the process. Secondly, we now have documentation and evidence of how GEICO was improperly accepting applications for insurance, not having the coverage selection form during the application process, and their alleged e-signature of how they try to do it post-binding of the insurance. We now have this evidence and documentation. They refused to provide it previously in arbitration, so at least we got the deposition of the person they generally rely on in arbitrations for certifications, who they would refuse to produce in arbitration. So we have those evidence, we have documents, internal records, which shows you their improper process. So what this will allow us to do is in future arbitrations going forward, and also possible additional class action lawsuits, we can use this evidence to show how GEICO has improperly handled applications for insurance, and specifically the coverage selection form, which is mandatory by law. Additionally, I will be putting this package together and forwarding it to the Department of Banking and Insurance to make them aware of the process, so that they can intervene when it clearly violates the statute, the regulations, and their own bulletins and orders of how they're supposed to get a coverage selection form filled out by the insured, signed by the insured, the applicant, during the application process, and then subsequently upon changes or renewals. So again, very disappointing, very frustrating, but this fight is not over. I will not let it be over. So if you know anyone who has a GEICO insurance that they're told after the fact, particularly after a car accident, that they only have $15,000 worth of PIP coverage, and they never saw, filled out, or signed a coverage selection form, which is typically the process for GEICO, please have them contact me at 732-722-2911, or they can email me at sean@seanhaganlaw.com, and I'd be happy to speak to them, find out the facts of their case, and see if they have a case against GEICO. This was clearly a violation of law. This was a case where there was at a minimum disputed facts, with the credible facts being that GEICO did not obtain a signed coverage selection form by this applicant, nor insured at any point. So hopefully we'll be successful going forward, but at this point we had a slight setback. Next, I wanted to talk to you about the feature provider of the month, Perrone Wellness Center. Perrone Wellness Center is located, as you can see on their website here, in Hackensack, New Jersey. They're on 6 Spring Valley Avenue in Hackensack, New Jersey. And they have hours between Monday through Thursday from 9 in the morning till 7 at night. They've been in practice since 1999. They provide chiropractic, physical therapy, pain management, and they handle personal injury, particularly auto lawsuits. Dr. Perrone is very personable, very caring, very attentive. Again, been doing it on his own since 1999. If you'd like to book an appointment, you can book online at this webpage, or you can call them at 201-489-9555. If for some reason you have any trouble booking this appointment, you can always reach out to me and I can also make the connection. So congratulations, Perrone Wellness Center, on being our featured provider of the month. I look forward to continuing to hear from you and work with you. So for anybody who's been watching our videos, each month we pick a winner to be featured in our next video. All you have to do is communicate with us anyway. Telephone calls, emails, stopping in, sending your arbitrations to be filed at no cost to you. And we put you into a poll for being selected. If you don't win this month, there's always next month, so keep those communications coming. And this month's winner is Hudson Regional Health. Congratulations, Hudson Regional Health. I'll be in contact with you to be featured in next month's video. Well, we hope you enjoyed this month's video. It's good to be back. We look forward to seeing you soon. Enjoy what little time is left of summer, and let's get to the fall, but let's not rush it. Again, if you've enjoyed this video, please like, share, and subscribe to the links below. As always, we're never too busy for your kind New Jersey PIP and personal injury referrals. Thank you, and God bless.